Thank you so much for joining us for tonight's Connected Conversation, a program conducted by the Idaho Humanities Council. If you're not familiar with our organization, I encourage you to check out our website, idahohumanities.org. I'd like to remind you all that you may submit any questions using the Q&A feature located at the bottom of the screen. With me tonight is Dr. Carrie Hunter, professor at College of Idaho. It's an honor to have you with us tonight, and I turn it over to you.
All right, thank you, Doug. Welcome to the College of Idaho. I'm here on our campus in the room where I'm teaching this term. I'm teaching in an empty room because our students are all distance learning, but we're teaching in an interactive way, so I can continue using my Socratic way of teaching. And I decided tonight I'd just come up here in the same room where I can feel free to wander around, maybe scribble something on the whiteboard, just to keep me kind of energized. But I'll go ahead and get started. So in 2009, with the help from a grant from the Idaho Humanities Council, I headed off to New Zealand to gain better insight into their political culture. I'd gotten interested in New Zealand as a test case somewhat to challenge the late Ronald Dworkin's argument that the best way to take minority rights seriously was with the help of a written Bill of Rights and an activist Supreme Court willing to stand up to majoritarian legislation, be it at congressional level or at the state legislatures. Dworkin, who was considered a liberal constitutional law philosopher or scholar, professor, makes a pretty good argument that you can't you can't have the majority check the majority. That's like having the fat fox guard the hen house. And so there was, to take minority rights seriously, one really does need an activist court willing to stand up to legislation and rule it unconstitutional. And examples such as court cases such as Brown v. Board of Education, where the court overturned previous precedent claiming racial segregation was constitutional. Brown v. Board of Education, they overturned that doctrine. The doctrine is separate but equal. Roe v. Wade obviously also came to mind, or comes to mind. New Zealand, however, does not have an American-style Bill of Rights. They eventually did pass a Bill of Rights, but it's nothing more than another act of Parliament. It has no more authority than any act of Parliament, and can be and Parliament can supersede it at any time. Nor are the justices empowered to question the constitutionality of the legislature. They don't have a written, or what they call an entrenched constitution like what we have here in the US. And so their justices just don't have the opportunity to hold the law up against a written constitution and say this law is unconstitutional. And so I wanted to see, again, I wanted to test this argument. So I got looking at New Zealand from a distance, from here on this side of the globe, and I discovered some really fascinating things. From a distance, it seemed like New Zealand was actually doing quite well in taking care of minority rights. For example, in 1986, the same year, the US Supreme Court ruled that since the words homosexual sodomy do not appear in the US Constitution, that state legislatures did not have to grant same-sex couples the same right to privacy in their own bedrooms as was a constitutionally required protection for heterosexual married couples. That same year, 1986, New Zealand granted same-sex couples the right to legal unions. Similarly, though European settlers had for the longest time in New Zealand violated the Treaty of Waitangi between the British Crown and Maori chiefs, starting in the 70s, New Zealanders actually began making reparations to Maori tribes in an attempt to make amends for such violations. I mean, to the tune of millions of dollars. Maori had also become an official language in New Zealand, and Maori were guaranteed a certain number of seats in their parliament. So certainly their native population was being treated far better than how the U.S. has treated its natives. And all of this was being done without a written constitution. And I was curious, how is it that after 100 years of European settler mistreatment of the Maori, they suddenly started to make these kinds of changes? They created a Waitangi tribunal. That tribunal started hearing cases to deal with mistreatment of Maori. And over and over, I saw examples of New Zealanders capable of caring for minority rights. So again, with the help of a grant from the Idaho Humanities Council, I headed over to New Zealand to get just a better sense of what New Zealand political culture felt like in person, or on the ground, as they say. Prior to going, with the help of the internet, I was able to set up a bunch of interviews. I was only there for about 6 weeks, and I spent time in all of their major cities at various universities, and then and several weeks in their capital city, Wellington. And I was able to meet with leaders in academia, constitutional law, scholars, the authors of their more prominent texts, various commissioners of various government entities, such as the Human Rights Commission, the Child Commission. When I met with the Child Commissioner, she was under a fair amount of fire for recently having passed the anti-smacking law, i.e. spanking. In New Zealand, they call it smacking. And the government had made a law against beating children, spanking children. And she was taking a lot of flack for creating more of a nanny state. But indeed, they have a commissioner to look after the children. That seems kind of cool to me. I also met with members of the Ombudsman's office, and I'll talk more about that later. But the Ombudsman's office is set up to look for individuals to, well, go ahead and talk about it now. For individuals to take complaints if there's a law that they feel like is mistreating them, they can take their case to the Ombudsman's office. They don't have to hire a lawyer. Anybody can do this. They have to fill out some forms. They have a number of personnel working in the office. They take their case to the Ombudsman, and the Ombudsman's office does thorough research, and every now and then they issue a ruling. Now, it has absolutely no force. The Ombudsman office can say whatever they want, but it doesn't have the force of law behind it. But the fascinating thing is when the Ombudsman's office speaks, people listen. The Ombudsman can say, yeah, Parliament, you may want to reconsider this particular law that you've passed because it's having these kinds of negative impacts on real people. And again, they can't force the Parliament to make a change, but the Ombudsman office shares a fair amount of respect in New Zealand, or enjoys a fair amount of respect. And because of that, when they do issue a ruling, it usually carries with it a fair amount of clout. I also met with a number of members of Parliament, including a relatively new member, a young lady by the name of Jacinda Ardern. you've been following much politics lately, you know that Jacinda is the current prime minister, one who has kind of been the darling many nations as they look to see the way she dealt with gun issue after the shooting in the mosques in Christchurch. Within weeks, under Jacinda Ardern's leadership, they were able to remove the kind of weapons that were used for that shooting and make them illegal in New Zealand. I also met with members of the press, two former prime ministers, so one future prime minister and two former prime ministers, one of which had long advocated, still continues to advocate, for an American-style constitution for New Zealand. He was actually the author of their Bill of Rights, that piece of legislation passed by the Parliament, which again doesn't have the same kind of gravitas that the U.S. Bill of Rights has. But again, it was a very heady experience meeting with all of these people. And almost from the first day that I arrived, probably the first day that I arrived, as I started meeting with people, I began to sense this really powerful, omnipresent emphasis on fairness. If you go to New Zealand, trying to gain an appreciation for their political culture, it's like you can't miss it. It's almost palpable. It's just so ever present. And in fact, a few years after I returned in 2012, a historian by the name of David Hackett Fisher, some of you may recognize some of his works, but he published a book comparing the U.S. with New Zealand. The title of the book is Fairness and Freedom, the history of two open societies, New Zealand and the United States. And in his book, Fisher argues that you can actually trace New Zealand's focus on fairness to their founders. People that left Europe for New Zealand when they're seeking a more fair opportunity. And he makes a similar argument. People who came to the U.S. came here seeking freedom. And it's a fascinating book, and he's done a tremendous amount of work. And I'm a little cautious of single variable analyses of this nature. But he looks at all manner of documents. He tries to look at the letters that are written, those sorts of things. And he constructs a fairly fun narrative that arguing that New Zealanders were interested in fairness and still are, where the U.S. Americans are interested in freedom and still are. Yeah, so it was really quite an eye-opener to me to go there. I also discovered a vibrant and extremely open and transparent democratic process. It was such a contrast with what we find here in the U.S. I really found that if you really want to study politics, New Zealand's a great place to go because they are so open, so transparent, and so. Again, here I am, a stranger from America, getting interviews with former prime ministers just by asking, cold contacting them via email. And it's just a delightful experience to be involved in, and then to see a parliamentary system that functions so well. If a problem rises, they deal with it. And I found myself sort of casting about for some explanations. And I was particularly struck by that office of the ombudsman, which I found myself thinking it's almost like an institutionalized conscience for the nation. It's almost like, I don't know if you've seen that, the old Pinocchio, or the old, Pinocchio, Jimmy the Cricket sitting on Pinocchio's shoulder, whispering in his ear, trying to be Pinocchio's conscience. The ombudsman's office serves that role for New Zealand politics. And I found myself envious. We need one of those. I found myself thinking here in the U.S. And I trying to find, in my head couldn't help but want to start trying to come up with theories. And I actually found myself thinking that maybe New Zealand democracy had an advantage on the US due to the very lack of having a written constitution. That is, when Parliament acts in New Zealand, the courts can't come along and say, no, you can't do affirmative action. Or no, you can't do this. It violates our Bill of Rights. I mean, it's one thing to have a progressive court trying to promote minority rights, but when you have a court which is becoming increasingly less progressive and quite willing to overturn acts of the legislature, such as, oh, here in the U.S., well, I don't know, maybe the Supreme Court and Citizens United was protecting the minority rights of corporations, and in so doing, frustrating democracy. So again, I found myself literally questioning: is the presence of the U.S. Constitution a stumbling block for progressive political agendas? Obviously, I couldn't forget the role that the court has played in the past in promoting certain minority rights. But clearly, one of the challenges of the Dworkin thesis of the court protecting minority rights became very evident. Well, which minority are they protecting? And if you look at the history of American Supreme Court rulings, the court's been relatively consistent in protecting the minority rights of property holders and corporations. So again, I find myself wrestling with all of these questions. And eventually, after a number of years, I end up writing this book. The title of my presentation today, I'm not sure where I need to hold this so that you can see it. Maybe there's nowhere that I can hold it so you can see it, but it's titled Approaching the U.S. Constitution, Sacred Covenant or Plaything for Lawyers and Judges. I got those words, sacred covenant, from the Casey opinion in the Supreme Court in 1992, Planned Parenthood versus Casey, where the Supreme Court claimed to uphold the essential holding of Roe v. Wade. And toward the end of the opinion, O'Connor, Stevens, and Kennedy, the authors of that opinion, remind us that the Constitution is a sacred covenant. And in so doing, trying to claim, emphasizing that we can't just treat it like just words in a legalistic sort of way. And then the other phrase, or plaything for lawyers and judges, a number of years ago in New Zealand, when they were pushing, when Palmer and others were pushing to create a American-style constitution, they went to the Maori and told them, you know, we could include the original Treaty of Waitangi as part of our written constitution, and that would give it more power. And the Maori said no. They were afraid that if New Zealand created a written constitution, it would become used like the U.S. Constitution has so often been used, in a legalistic sort of way, and become a plaything for lawyers and judges. I got permission from one of my New Zealand scholars to borrow that phrase from him, which I found in one of his pieces. And so, again, the question becomes one of how do we approach our Constitution? Is it a sacred covenant or a plaything for lawyers and judges? And my thesis is obviously, it should be obviously, I guess, by now, that I believe it should be treated more as a sacred covenant. And I got thinking about some of my old reading, and I remembered Alexander Hamilton's Federalist 78. In Federalist 78, Hamilton points out that the Supreme Court is the least dangerous branch in the U.S. and U.S. institution, federal institution, because it does not have the power of the purse, nor does it have the power of the sword. It cannot implement any of its rulings. It literally is totally dependent on others for implementing its rulings. And even though the US Constitution, even though the framers considered the idea of including the power of legislative judicial review, that is the power for the court to actually look at acts of the legislature and rule on their constitutionality, it's that the founders refused to put that power in the Constitution. Even though they did refuse so, Alexander Hamilton still thought that the justices would feel compelled to look at the Constitution and ask whether legislation passed by any state or federal Congress, any state legislature or federal Congress would look at the Constitution and ask if legislation was really in harmony with the Constitution. And Hamilton argues that the judiciary needed to be independent and they basically have life tenure, that at least on good behavior, so that they would be willing and able to provide the arduous duty, his words, of challenging Congress and not having to fear that it could come back and haunt them. So in a sense, from Hamilton's perspective, the role of the US Supreme Court is very similar to the role of the Ombudsman's office in New Zealand. And so I found my wishes granted. Indeed, we do have something like the Ombudsman's office. Now, it's not quite as good. You have to hire a lawyer, but maybe if you're lucky, you can get someone to take up your cause. But in all reality, as Hamilton argued in Federalist 78, the only power the US Supreme Court has, certainly had back then and currently has today, is the power of persuasion. The Supreme Court can its rulings only have as much effectiveness as we're willing to give them. And you know, when you listen to the media talk about the court, or you listen to members of Congress or all various critics of the court talk about the court, it's almost as if they've forgotten that. It's almost as if they think that when the Supreme Court rules, that becomes the law of the land. But that's just not true. If you look at the reality, the reason why we are now entering a very fraught period of time with regard to selecting a new justice to sit on the Supreme Court. One reason why is because there still is this hope to overturn Roe v. Wade. Well, Roe v. Wade was decided back in 1973. Since then, the court has heard numerous cases where state governments have been unwilling to abide by the Supreme Court ruling in Roe v. Wade and pass legislation that violates that ruling. And so a new case ends up in front of the Supreme Court, and the Supreme Court ends up issuing a new ruling in 1992, the Casey case that I mentioned earlier. In my mind, in many ways, really did overturn Roe v. Wade. It held it up in name. It claims to have held it up in the essential holding of Roe, but it really did dial back a woman's right to reproductive, making reproductive decisions, at least during that first trimester. And prior to 1992, Roe v. Wade basically demanded that a woman had virtually an absolute right to not be interfered with during the first trimester. 1992 Casey case ended that, and states have been and created this new standard called the unduly burdensome. States can put in regulations regulating abortion so long as they're not unduly burdensome. And so states will try something, and the court ends up having to decide on whether or not that is unduly burdensome. Most recently, so-called conservatives, I say so-called because it's not clear to me that it's conservative to want a government bureaucrat interfering with one's private decisions with regard to pregnancies. But the most recent case that really disappointed conservatives who thought they finally had made it with Justice Kavanaugh. Again, a new case came before the court because states were pushing the limits. Supreme Court, in spite of Supreme Court's ruling, in fact, this case that came before the court was exactly like one that the court had decided on just a few years earlier, and that was regard to the idea that doctors had to have admission rights in a hospital if they were going to provide abortion practices. And the court had ruled, no, that's unconstitutional. It's too burdensome. States ignored that ruling and came up with a similar, almost identical ruling or law, hoping that this time the court would uphold it, and once again the court voted against it. My point being, Hamilton's vision of the court, I mean, Hamilton hoped that the court would develop the kind of political legitimacy that our court has today. It clearly didn't in his time. But if you think about the court, I mean, it has developed a certain amount of legitimacy, but its power lies only insofar as we think of it as legitimate. And as my phrase "plaything for lawyers and judges" in the title of my book implies, when the court treats the Constitution as a plaything to be manipulated by lawyers and judges, that's when they lose credibility. Hamilton predicted this in Federalist 78. He said, if the court ever starts using a legalistic kind of approach to making sense of the Constitution and uphold laws that clearly seem unjust under the argument, well, the law is the law and there's nothing we can do, it will lead to cynicism and a deep lack of respect for the court. And in my book, I look at examples like the Dred Scott case where Chief Justice Roger Taney said, you know, I know this really seems bad. It's hard for us to imagine how our forefathers thought about the black, I can't remember the terms he used, people from Africa, the slave race, but they simply viewed them as not ever being capable of ever having citizen rights. And so, sorry, Mr. Scott, nothing we can do about it. You are not a citizen and we cannot help you. This is the kind of language that Justice Scalia liked to use. It's the language he used in 1986 when he said, you know, I don't have anything against gays. I'm not sure I believe him, but he said, I don't. But hey, the words homosexual sodomy don't appear in the Constitution. So no one has a right to engage in that practice. That kind of legalistic thinking is what hurts the court. Now my next move, and that is I want to look at the Chief Justice Roberts and his court as umpire approach. Now, Roberts tried to claim a certain amount of humility when he went before the U.S. Senate Judiciary Committee, and he said to them, no one goes to a ball game to watch the umpire. The umpire's job is to simply call balls and strikes in an objective sort of way. Now, I don't know if Chief Justice Roberts has ever gone to a ball game, but anybody who's ever paid much attention, certainly the players know, that umpires have their own idea of what the strike zone is. And if an umpire calls a ball a strike, there's nothing anyone can do about it. if the goal of our the so-called conservatives is to dial back the political power of the court, the last thing that they want to champion is the idea that the court is like an umpire. Umpires have dictatorial powers. Umpires say what it is, and that's what it is. And if I haven't convinced you yet, imagine this scenario. Somebody goes up to bat, swings away, hits a ball, a home run, and the umpire says, throw that pitch again. I'm not going to pay any attention to that. That's what, I mean, the Supreme Court has the ability to set its own agenda. And through the agenda setting business, it's very much engaged in anything but objective practices of an umpire. Umpires don't get to set their agenda. They've got to make a call. The ball's either a home run, and it looks like it went over the fence, or it's a foul. So they don't get to set their own agenda. So it's just the umpire ideal is a really bad ideal, and if we do think them as umpires, we empower them with dictatorial authority, and especially if they get to then decide which balls to even look at, that's even more dictatorial. So it's a bankrupt notion. It's not a good way to think about the court at all. Justice Scalia was fond of saying, the citizens are not going to have any faith in us if they think that we're letting our personal values come into play here. But how dumb does Scalia think the citizens are? Why does he think he was put on the Supreme Court? Why is this current controversy becoming a controversy? We know that people are put on the court precisely because of their personal values. So I argue in my text that what we really need are justices who will openly embrace the difficult challenge of wrestling with our most ethical, challenging questions as their conscience might. Or the court will say, I smell a rat. There's something wrong with this piece of legislation. It feels wrong. Hamilton suggested that justices should even look at the intentions of legislatures and call them out when their intentions are nefarious. This doesn't destroy faith in the court when the court does it, especially when we understand that the best thing the court can do is to be our conscience. You look at Brown v. Board of Education, the case I mentioned earlier. You cannot find any legalistic thinking in that case. The primary logic that Chief Justice Warren uses is that allowing schools to remain segregated will do irreparable harm to the hearts and minds of the nation's children. That's not, you can't find those words in the Constitution, therefore there's nothing we can do about it. That is making an appeal to our better selves and having the court be a sort of a beacon, a conscience, telling us we can be better. We can use the Constitution, we can use the aspirational elements of the Constitution to make a more perfect union, and the court can help us if in their rulings they don't go down this legalistic direction that make us feel like, wow, who might argue with the court? I can't even understand what their opinions are even saying. So my argument is the court needs to talk to us in a way that we can understand, and in a way that appeals to our better sense of justice. The ideal, a government of law, not of men, becomes a government of law men, and increasingly women, when the court acts as our legal guardian. Law men and women who understand this very complex bunch of past cases, etc., that boggle the human mind. Chief Justice Marshall argued in McCulloch versus Maryland, we've got to remember it's a constitution we're dealing with. It's not a legal document. The Constitution was not written by any state legislative body. It's bigger than that. It's not the supreme statute of the land. It's the supreme law. Law understood in a very broad way. Government of law, not of lawmen, lawyers, judges. Obviously, the challenge is how do we start doing that? And again, in my mind, I teach constitutional law, so I do my best to try to help my students who are going off to practice law or going off into politics to understand how this particular vision of Hamilton's. But I'm just one lone little professor here at the College of Idaho, and I think my vision is the correct one. Again, it's not mine so much as it's Hamilton's, and I think I'll probably call it good right there and go ahead and start taking your questions.
Thank you for all the information. That was definitely a timely presentation, and I will say I'm very jealous of your trip to New Zealand. I bet it was amazing. So to open up, do you think the US will ever be able to transition into the model that New Zealand has regarding the Supreme Court being more of like that conscience on the shoulder rather than, you know, this is the definitive answer?
Well, it will really happen only to the extent that justices embrace that role. Again, they have. Brown v. Board of Education is an example where they have.
Mm-hmm.
The Casey case was an attempt by the three justices who wrote that plurality opinion to try to make some nod towards pro-life folk and pro-choice folk in a way that kind of bridge that. It didn't succeed, obviously, but the court has in the past, and I'm guessing in the future will have those kinds of rulings, but only if we can kill that silly notion that the role of the court is to be like our current chief claims, which is a umpire calling balls and strikes. Now, I will say that Chief Justice Roberts understands the importance of preserving the legitimacy of the court. In fact, if you look at the last 3 or 4 years, a Gallup poll shows that support for the court has been increasing, slowly, but increasing compared. I mean, over the years, it's remained within a, usually above 50% approval rating, so much better than our other national institutions. But Roberts has disappointed a lot of conservatives. Roberts actually spoke out against Donald Trump, who likes to view judges as either, or justices as either Democrats or Republicans, and Roberts said, no, we're not. Roberts is trying his best to be neutral, but he's also been willing to almost go against what the conservatives thought when they put him on the court in order to show his commitment to neutrality. But in the end, I'm convinced that neutrality is not enough, because we all see through it. We know there's all of this politics going on. And I think it would be healthier for our society if our justices acknowledge that there is something they can do about it. That what they can do is they can appeal to our higher values, our higher sense of justice, and say a law seems unconstitutional for those reasons. The only way it'll happen is if with inside lawyers and judges begin to recognize the need for that. Doug, but I'm not holding my breath. Occasionally it'll happen.
And then earlier when you were talking about New Zealand, you mentioned how they do a really good job with minority rights. And New Zealand tends to be more of a homogenous country with just the two groups, typically, at least on the forefront. The Maori and then the Caucasians. So do you think that makes it easier for them since they're really dealing with one major minority group rather than in the US where we have a large prominence of multiple different groups?
You know, it's fascinating. I always get that question, and it just really demonstrates our ignorance over here with regard to New Zealand culture. That I don't remember the precise date, but when I was there, the way the current demographics were looking, the trends were looking, by the year 2025, or maybe it was a little later, there would be no majority. There are a lot of Asians. It's a very diverse population. So it has nothing to do with diversity. It might have something to do with the size, but I'm not even willing to buy that, because small states in the US can be very unwilling to look after their minorities, right? And that's part of the problem why people continue to look to the Supreme Court to overturn acts of state legislatures. They can be very nasty when it comes to minorities. So no, I don't think it has anything to do ultimately with size or diversity. They're more diverse than we are. It's just a commitment to fairness. You know, every now and then we get these new reality television series. And when I was in New Zealand, the one that really caught my attention was one called Fair Go. That is, everyone deserves a fair go. That's the language they use in New Zealand. And so they actually had a reality television program called Fair Go, and people get to bring their complaints, and it was not, it's just, they're just more interested in being fair. And again, since they don't have a constitution that can be interpreted in this legalistic fashion, that helps them to do that. They couldn't believe what we're doing right now. We actually, like 90 days before an election in New Zealand, you can do no major legislation. You certainly can't go around putting people on the court. I mean, they recognize that that's just wrong. Now, there's no law that says you can't, but there's a custom. They call it a constitutional convention, which I find fascinating. They have a convention that says, no, that's wrong. So it boggles their mind. I mean, we call ourselves a democracy of sorts. The kinds of things we do in the name of, well, that's what the Constitution says. That's what Mitt Romney said just today. The Constitution says it's the job of the president to elect the next president. That's what all the other Republicans are saying, who were saying earlier, 4 years ago, that's too bad. That's not the job of the president. It should be the people who get to have an election before we pick someone else on the court. That kind of crap doesn't happen in New Zealand because they just have this culture that is not tied to the words of a constitution. I'm passionate. Go ahead, next question.
One definition of legalistic is adhering sometimes excessively to the black and white letter of written law, similar to what you just said. Isn't this inherent in the concept rule of law versus rule of benign potentates?
It doesn't have to be. It depends on how you understand the word law. Law can be, again, I wanted to differentiate between law and statute. And I look to Chief Justice Marshall in McCulloch versus Maryland, where he does the same. Now, the same Chief Justice Marshall in Marbury versus Madison, which is the case first time that the Supreme Court overturned an act of Congress, because the Supreme Court was kind of tentative initially, knew it didn't have that authority written in the Constitution. In that case, he does talk about the Constitution as like a legal document. Marshall was willing to use the Constitution, however he felt he needed to use it in order to accomplish his vision. But in McCulloch versus Maryland, he emphasizes this is a constitution, not a statute. And if you get studying legal or the ideas of law, there's natural law. This idea of law is much broader than the idea of a narrow legalistic way of thinking. That can be the way you approach it in a legalistic way, and in so doing, turn everything into a plaything for lawyers and judges with all manner of fine print that no one can understand but a lawyer, and a lawyer can twist it one way or the other. That's a very narrow way of thinking about the rule of law, and it's not one that I think we should embrace, nor must we embrace. When we allow that to be what rules us, then we really are being governed by lawyers and judges, not the law.
And then the American Bar Association's Model Code for Judicial Conduct, which has been adopted by Idaho for their state judges, provides that judges and judicial candidates shall not, in connection with cases, controversies, or issues that are likely to come before the court, make pledges, promises, or commitments that are inconsistent with the impartial performance of adjudicative duties of judicial office. Do you agree with that provision?
Well, as a professor of political philosophy, the word impartial I find completely problematic. Again, it's that idea of an umpire attempting to be impartial. We humans are far from capable of being absolutely impartial. It's a particularly good standard to try to uphold. We also have the Lady Justice as one of our ideals, right? Lady Justice, which is blindfolded. The idea being that justice is impartial. That is, justice should not judge you based on your sex or your gender, your sexual orientation, or the color of your skin. And so impartiality in that way, I think, is a tremendously wonderful ideal. And indeed, I think judges, when looking at a judicial proceeding, should behave that way. But notice, and I talk about this a fair amount in my book as well, the U.S. also has another ideal, and that is a jury of one's peers. Now, that ideal is actually totally opposite of impartiality. The jury of one's peers ideal is saying, well, we think that peers have a kind of partiality that will allow them to discover capital J justice better than the legal law that might be written by legislation. So a jury of one's peers, and anybody who knows how juries operate, understand that once you get behind closed doors, the juries can kind of do anything they want. And the jury of one's peers ideal is intended for that. If a law, and in fact, initially there were those who believed that it would be the jury trial that would protect against bad legislation, unjust legislation. If a law seems to be treating people unjustly, that can be dealt with in the jury of one's peers. So yeah, in some ways, it's the job of the government when looking over a trial to be as impartial as possible, using the Lady Justice theory or approach. But the jury, actually, by ideal, is meant to be more partial in an attempt to discover true justice for that situation, if that makes sense. So in a sense, what I'm saying is, again, and I also, we should emphasize, when the Supreme Court is acting as a purely in its appellate role, that is looking to see if the process below was following the procedures, that's one thing. But when you're engaged in legislative judicial review, that is questioning the constitutionality of legislation, they don't have a legal authority to do that. So they would serve us better, in my mind, if they acted like the ideal of a jury of one's peers. If you're going to speak out against a legislation, speak out against it based on its inconsistency with justice, as opposed to whether or not the words homosexual sodomy show up in the dadgum document. Longer answer than you expected, but sorry, it was necessary.
And since New Zealand doesn't have a constitution and that seems to be working really well for them, do you think there is a possibility of the US ever transitioning into not having a constitution or just completely redoing our constitution? Or do you think that's like a too far gone of an idea?
That was kind of what was hanging me up, when I first got back to New Zealand. I'm trying to figure out what to do with all this information. Hence the title, Approaching the U.S. Constitution. Having a constitution is not our problem. Our constitution can serve as a very forward-looking, idealistic, the idea of everyone having equal protection of the law that's written in the 14th Amendment, there's nothing wrong with that. It's how we approach it. So, yeah, is it possible that someday we'll have some other constitutional convention and change it? I suppose it's possible. I don't think it's probable. It's just so difficult. But another way of sort of addressing that, again, would be we have certain justices on the court and certain law professors who are really into this notion called originalism, and they want us to interpret the document precisely as it was intended by those who originally wrote it. Well, that too is a false notion. One, there was not a single original view. People who signed on to it for various reasons. Secondly, we don't know exactly how each word meant to each person who signed on to it. Third, as New Zealanders ask, why would you allow yourself to be governed by a previous generation? Why would we think of them being smarter than we are? So if you approach the Constitution in the way one of my favorites, Justice Brennan, did, as a living document meant to help us deal with our current problems in a way that is fair and just for all, as much as possible, the current Constitution can work fine. There's no need necessarily to amend it, as if we would just approach it more as a sacred covenant and less as a plaything for lawyers and judges.
And then this might be our last question for the night since we are running a little short on time, but someone is wondering what might need to change to produce a Supreme Court guide by the principles of persuasion that would enable it to act as our legal guardian in a way that isn't guided primarily by power moves. And then would that be a problem for Congress for deciding who gets appointed to the court, or is that a problem for voters?
So voters are pretty much in over their heads on these sorts of things. We don't know. I mean, your average voter doesn't pay that much attention to the court. There's a institution called the Federalist Society where all judges who conservatives like anymore pretty much have to be a member of. And they tend to sign on to things like Robert's umpire approach and that legalistic notion. They promote things like trying to come up with an absolute, almost a dictionary of terms that govern. Um, and I guess what I'm saying is what we probably need is a similar sort of society that would have to be embraced by law professors at law schools, our most prestigious ones, Harvard, Yale, etc. A similar society that is committed to Hamilton's vision. And those sorts of organizations can really impact things. Now, is it four people on the Supreme Court now, the conservative justices, all were part of that society? So there are ways, odds are I'm not going to be able to do it here in Caldwell, Idaho, at the College of Idaho. Maybe some of my students who go off to prestigious law schools will be able to begin having these kinds of influences. You never know. I mean, 3 or 4 people who are committed to a particular vision in the right place can begin hammering away at this sort of thing and make a change. For the longest time, this is my 33rd year at the College of Idaho, for the longest time I've tried not to profess. My job, I see my job as one of challenging students, engaging them in a dialectic where they make some claim and I challenge that claim, and we interact with each other and we come up with a synthesis, and then we challenge that. My job has been to question. But after I came back from New Zealand and wrote this book, I began professing for the first time in my history, in my career, because I do believe that Hamilton's vision would be so much healthier for the country to embrace. And so, yeah, I deal with students who do go off to some of our best law schools in the country regularly. And, you know, until I got this question from you just now, I hadn't thought about maybe we need to start creating this new society. Yeah, I've got a student who right now has just started Georgetown Law. Maybe I'll send him an email after tonight's meeting.
Well, I'm glad that we were able to get you thinking. And unfortunately, we are out of time. So I wanted to say thank you for attending tonight, everyone, and thank you, Dr. Hunter, for joining us.
So thank you. And if there's anyone that would like to engage me further on any of this, feel free to get my email address from Doug and send me an email. We can chat more, or even have a Zoom sort of thing if you'd like. Thank you.
Good night, everyone.